Hello, and thank you for joining us for the next episode of the Emerging Tech webinar series. Today's episode will cover the top 10 things you need to know about medical device patents. Our speakers today will be Ryan Connell and Doug Portnow. Ryan and Doug will give an overview of some IP fundamentals, as well as some issues that are specifically related to medical device patents. Feel free to enter any questions using the Q&A feature on the Zoom menu. A recording of the webinar and the slides will be emailed to all registrants. And with that, I'll hand things over to Ryan.
Hi, everyone. Thank you so much for taking time to join us today. My name is Ryan Connell. I'm a patent associate at Schwegman, Lumberg, Wilsner. My practice area is in the chemical arts, mechanical arts, and of course, medical devices. I'm going to start today's webinar by going over a general overview of patent law, and then I'll turn it over to my colleague Doug, who's going to talk about some aspects that are a little bit more focused to medical devices. So, the first topic that I want to cover is just a general overview of the different types of intellectual property that are relevant to medical devices. Generally, IP that's relevant for medical device includes trademark, copyright, trade secrets, and patents. And I'd like to start by talking about trademarks. A trademark, or service mark as it's sometimes called, is a mark such as a word or symbol used to indicate the source of goods or service. Generally, they take the form of logos that we're all familiar with seeing. For instance, I've got an array of them here: McDonald's, Google, Coca-Cola, KFC, Apple. And really the intent of these marks is to give consumers confidence that when they buy a product that's branded with this logo, that they're actually getting what they intend to get. So when I buy a Coke, I want to be sure that I'm in fact getting a Coca-Cola and not a knockoff soda. So a trademark is actually examined and registered through the United States Patent and Trademark Office. It goes through its own examination process like a patent would. Once you get it registered, the term of the trademark can last more or less indefinitely, so long as it's used in conjunction with a product. As far as the medical device realm is concerned, trademark can be a really useful form of intellectual property in your portfolio, in that you can trademark your company's name once you have that settled, or if you have a logo associated with it. You can also have trademarks for the individual products or devices that you're making, and that you can register as well. So you can really give consumers confidence that the products that they're getting are in fact yours and not a knockoff. And trademarks also aren't just limited to a logo. They can be a color of a product. They can be associated with a sound or even a smell, if you can believe it, in some limited circumstances. So trademarks are really something that can be an important member of your IP portfolio. The next form of IP is a copyright. So copyrights are used to protect original works of authorship that are fixed in a tangible medium. Some of the most common examples, are movies, a recorded song, photograph, books, sculptures. A copyright is actually created the moment that it's fixed in a tangible medium. When you go through to get it registered, which is a relatively straightforward process as far as legal processes go, once you actually get it registered, then you can enforce your copyright action in an infringement lawsuit. And once you do get it registered too, or even before, you can denote your material as copyrighted, since the copyright's created once you fix your authorship in a tangible medium. And you can see, as an example, in the bottom right of our screen, we've copyrighted this presentation. Copyright, you might not think of it in terms of your medical device IP portfolio necessarily, but it can be handy if you have created marketing material around your device, if you have an instruction manual, operator manual, really anything in writing that's associated with your product, so that if somebody were to look to make a copy of your device, they're not also just given a copy of how to use it. So this again can be an important part of your IP portfolio for whatever device you're creating. The next class of intellectual property are trade secrets. Trade secrets are a really interesting genre of intellectual property. Trade secret, as the name implies, is anything that you can keep secret. So if you have an invention or a product and the kind of nuts and bolts of it, if you will, are things that aren't readily apparent or easy to reverse engineer, you can actually keep that a secret and protect your intellectual property that way. Maybe the most kind of common or famous trade secret is the Coca-Cola formula. And that's an example where you have a formulation that even if the constituents themselves, if you can determine what those are, it's tricky to go back and determine what amounts they're all present in, how they're mixed, when they're mixed, what processes go into actually making that final formula. And because it's so complex, that's something that can be that the company can keep close to their vest and not have to disclose and protect it. Trade secrets, though, have a major drawback in that the protection, while can last indefinitely, is only good for as long as the secret is maintained. The minute that the secret gets out there, either through accident or through someone intentionally doing it, once that's out there, your protection is gone. For the most part, you cannot claw that back with a patent. The reason being that once the secret is out there, it's disclosed. So there's kind of a cost benefit, if you will, to how confident you are that that secret can be protected versus if you think that there's a chance that there could be a reverse engineering or an accidental disclosure, the security afforded by filing a patent and in exchange for a comparatively potentially limited term. So the next form of IP is patents. And a patent is going to be the focus of our discussion today, although those other three forms are quite important and can be highly relevant to your medical devices. So a patent gives the patent owner the right to an invention for a limited period of time. The trade-off is, unlike a trade secret, you have to actually disclose the nuts and bolts, if you will, of your invention. Patents come in four general forms. The most common form is a utility patent. A utility patent is what's meant to cover a machine, a process, an article of manufacture, or a composition of matter. Again, these are overwhelmingly the most common application that's filed, especially for a medical device. Design patents are another form of patent. Those have been gaining popularity of late. Design patent is meant to cover an ornamental design. Ornamental designs are things that just kind of think something that is aesthetic, oriented for aesthetics. It can't have any kind of functional characteristics. So think, if you have a device and it has, certain curves here and there to make it look visually appealing, that's something that you can actually patent the design of. But none of those features can have any functional aspect. It can't be tied into the movement of a part of your device, or it can't can't do data output. Anything like that has to be purely non-functional. Plant patents are another form of patent. Those are meant to cover plant varieties that are asexually produced. And the last category are utility models. That's more of a phenomenon of international patent law. They kind of are, for lack of a better term, kind of a stripped down patent. They are a little shorter. The term isn't necessarily as long, but they're good for kind of quick improvement of your device if you want to capture those. But again, those aren't so relevant for U.S. law. But anyways, again, today we're going to be focusing on patents. There can be one of the most valuable assets you can have in early stages of a medical device company. Next slide, please. So just some general overview about a patent. A patent doesn't give the patentee the right to practice an invention in of its own. There's a misconception among some people that, especially in kind of the medical device or pharma realm, that once you get a patent, you can bring your product to market. But there are other hurdles that you might have to go through, like FDA approval and the like. And you have to understand with these agencies, the United States Patent and Trademark Office runs on a separate track than FDA, and approval in one office doesn't give you approval in the other. So just because you have a patent doesn't mean that you have FDA clearance as well. So you really have to make sure that you take a patent for what it is. And what a patent is it simply gives you the right to exclude others from making, using, or selling the invention, again, for a limited amount of time, about 20 years from the date of filing. And that's in exchange for you disclosing the invention to the public. And the policy justification being that this disclosure is worth the 20-year exclusivity because you've advanced the body of knowledge. And just to go back to my point up top about that you don't necessarily have the right to practice the invention, Doug is going to go through this in a little bit more detail later, but you do have to run what's called a freedom to operate search, or it's advisable to, before you launch a product, because even though you have a patent on something, that doesn't necessarily mean that your device itself isn't covered by a pre-existing patent that might have claims broad enough to sweep it in. But again, more on that later. Next slide, please. So I go through the process to get a patent. As self-serving as this may sound from a patent attorney, patents are important. Again, they protect your invention. They exclude others from making, using, or selling it. IP is property, and it can be monetized, and it has value. It can help you early on with your company's valuation. It offers proof to people that you actually have something tangible, that you had something that was developed enough to mature into a patent or justify a patent filing. If you're early in development, this might be the first form of property that you get, or it might be kind of the first kind of signs of your company growing if you don't have sales yet, if clinical data is being generated or hasn't been done yet, or you don't have other tangible property. And also, patents offer you a really wide array of ways to protect your technical space. Some people might think that you get one patent per device, but the truth is you can have any number of patents for any number of sub-features within your larger device that might be patentable themselves. You know, if you have your overall device, but there's some subcomponent or some sub-assembly that has unique mechanical features that themselves might be patentable, you can have a patent just directed to that and kind of corner off that part of the market. Or me as a chemist by training, sometimes I find when I look through medical device patents, there might be something unique and patentable about the material that it's formed of itself. If it's something that isn't generally thought to be biocompatible, or something that imparts, good strength factors or flexibility where you need it, sometimes you can have a patent in of itself that just goes after the material or a coating or something like that. So patents really give you a wide array of ways to protect your intellectual property. We'll go over this in a minute, but in order to get a patent, in the patent office's eyes, you have to have an invention that's novel, non-obvious, and enabled. And next slide, please. So when the patent office looks at your invention under those factors I just mentioned, what they're going to be looking at overwhelmingly are your claims. The claims outline the bounds of your patent protection. Really, a claim is analogous to a property description in a deed. It tells the world what you own, and in this case, what intellectual property you own. And so when you work with your patent attorney to prepare these claims, you go through this exercise of trying to find a way to draft the claims as broad as possible, that you can kind of cast a shadow, if you will, over a technical space with your patent that defines your boundary, but yet you want them to be reasonable or focused enough to your commercial product that you're not trying to claim more than you want to and leaving yourself vulnerable for invalidity attacks. So it's kind of a game, and you try to find the sweet spot. But really, the most important thing is you're going to want to make sure that the claims cover your commercial product. And then that's kind of the core thing that we want to make sure that we look at and that we want to be mindful of during the drafting process. Other things, when we talk about breadth, we want to make sure that the claims, to the best of our ability, that we can anticipate what some design around strategies might be, or maybe where the technology might evolve. So we'll want to look to make sure the claims can cover that. We also, one thing to consider when you're going through drafting is is when you list out the features in your claims, think about things that a competitor might look at and say to themselves, you know, if I just got rid of this feature, I could have a device, and while it may not work as well as the patented device, it can work good enough and I can get some market share. So you want to think about things like that when you're playing that out and deciding how broad or how narrow your claims want to be. But again, as you're going through the process, do make sure to continuously check and make sure that at the end, you're going to get a patent that covers at least your commercial product and some other stuff. Next slide, please. So again, how does the patent office examine your application? I think I got off sequence with my slides, but the four main categories that the patent office is going to look at in examining your claim are novelty, non-obviousness, enablement, and patent eligible subject matter. So patent matter, subject eligibility, that's typically not a problem in the medical device realm. You see that more as an issue these days in the biotech space and computer software space, where sometimes claims can be construed as reading on a product of nature, and that's not eligible subject matter. In the computer software applications, sometimes claims can be construed as reading on an abstract idea, which is not eligible. When you're dealing with a medical device, oftentimes you have a tangible product that's not a product of nature nor abstract. So it's really not a problem. There's one quirk with medical device claims that you can't have your claims construed as reading on a human. That's because of product of nature and also some kind of good policy reasons too. Sometimes this happens if you're a little loose with your claim and you say a device attached to a bone, that can be construed as reading on a human since it's attached to the bone. Easy workaround with that is you'll just say a medical device adapted or configured to be attached to a bone. Something like that is a workaround. If it happens, it's a relatively easy fix with the patent office. Your claims have to be novel. That is, if the patent office looks at your claims in light and finds one printed reference or published reference that recites each feature of your claims, they'll reject them as not being novel. Non-obvious, even if the patent office can't find that one reference that discloses each and every feature of your claims, they might say to themselves, well, it is novel, but the gap between what's known and what your invention is, we're going to say that's so small that someone that's skilled in the art would consider this an obvious improvement, and we're not going to let you have a patent for an obvious iteration. This comes up a lot. Oftentimes it's in the context of the patent office will cite two documents, and those two documents joined together will teach each and every feature. The last grounds that's typical that you get a rejection over is enablement and written description. That's just the patent office making sure that your claims are described well enough in the body of your patent application that you actually show that you actually did invent something. They want to get away from you having a claim where you claim something really handy like a cure to some disease, and then in the specification it's just hand waving and you don't really give any detail on how that's actually done. They're not going to let you have a patent. They're not going to let you have such a valuable claim if you can't back it up. So when you do write an application, you want to make sure you describe your invention full enough so that you can not subject yourself to that line of rejection. Next slide, please. So with patents, timing is important. These days, the United States has joined the rest of the world as being part of what's called a first-to-file country. That means that as far as the patent office is concerned, whoever files first gets the rights to a patent. So it doesn't, in the patent office's eyes, it doesn't matter if you came up with your invention and then a year later somebody came up with the same invention. If that later person files first, they're going to have the opportunity to get a patent and not you. So that puts a little bit of pressure on wanting to file, and sometimes there are concerns about how ready you are to file. How is it worth it or not? If you can decide that there's no commercial value in your invention, at least now, then that weighs against filing it. Or if you're not sure that you'll practice or a competitor will practice, those are considerations. Sometimes people are justifiably a little bit hesitant to file a patent before they've actually built their device. And but really the time to file a patent is when you can adequately describe it. And keep in mind too that the patent office doesn't require you to actually have built your device. Just writing an enabling description alone is considered a constructive reduction to practice. So if you can at least write out your application in a way that makes sense and describes your invention, it's ready to file. And also you can file what are called provisional patent applications in the United States. Those aren't the applications that are actually examined, but what they do is they secure your filing date with the patent office so that if something comes later, they can't block you. And when you file a provisional application, you get a whole year to kind of tweak your invention, and you can capture those improvements in the application that's ultimately filed and examined with the patent office. Next slide, please.
Ryan, before we jump to the next slide, there was a question, I think it's right up your alley from Mark. The question is, assuming I could get a patent awarded, is it advisable to try and get a new medical use patent on a generic compound like an amino acid? It seems like a Sisyphean task to prevent the patented medical claims tacked onto generic manufactured products. Would you like to address that now or hold that till later?
Yeah. Yeah, so if I understand the question correctly, so you're talking about if you have a compound and assuming that it's yeah, and you're talking about if you have a compound but you don't have a medical use for it quite yet, is it worth it to pursue a claim on the compound alone without the use? And generally, as a broad answer, yes. If the compound itself, if you're confident that there's novelty in the compound and that the compound isn't obvious, if the compound is otherwise patentable, absolutely. It's because if you can have a claim on the compound itself, then that sets you up really well to have a really generic patent application that claims a broad range beyond just patenting a use. So you would actually that way have a claim towards a product as opposed to a method of use, and that would set you up quite well. So it's kind of if this goes to timing, yes, if you have something that you're confident is novel and not obvious, then it does pay to file on that sooner than later. And especially in terms of what I was talking about with the provisional application, if you need to do further studies to determine the bounds of the use of it, then you can get that data in that intervening year potentially to make a stronger application later. So yeah, I would say so. Yes, that's correct. Someone said in response that there has to be some use asserted in the patent in Ray Fisher. That's right. And you can also, if you don't have the use fully determined yet, but if you have enough confidence or the ability to suppose what the use is, you're allowed to use what are called prophetic examples when you describe when you're doing your patent application. So if you can imagine the use and describe it clearly enough, then you can get over that hurdle of describing the use. So that's one way. If you don't have the invention fully determined yet, that you can satisfy that requirement. And as a follow-up to that, someone said you certainly don't need clinical results, and that is absolutely true. Thank you for the questions. I hope that answered it. And if you need more clarification or if that didn't address it, please do send a follow-up question. Just briefly, the patent prosecution process. Once you do file the non-provisional patent application, it typically takes 18 to 24 months or so until the examiner picks up the case. They will almost always issue a rejection at first. That's no reason to panic. Typically that's good because you tried to claim broad and then you can come back to something that the examiner will find palatable. It's kind of like if you put in if you're at the car dealership and the dealer takes your first offer, you might think you could have gotten it cheaper. In the same way, if the office accepts your first claims, you might wonder if you left some breadth on the table. And as you go through the process, you tend to amend the claims to get to something the examiner will find palatable. If you're not making any headway with an examiner and you want to get the case away from them, after a few rejections, you're allowed to appeal to get it away from them. And then ultimately the patent application is abandoned or receives a notice of allowance. And before the patent actually issues, you do have the opportunity to file what are called continuation applications. That's kind of what I was talking about before, where you can go over sub aspects of the invention. You can file a number of applications, all stemming from that one application once you have it filed. Next slide, please. Okay, and the last topic I'm going to talk about is where to file. One thing to keep in mind is just because you're a U.S. company, well, if you are a U.S. company, you don't necessarily have to file in the United States first. And in fact, this is something to talk about with your patent attorney because depending on, in some circumstances, wherever the inventor is, where they claim citizenship to and where their inventive activities took place, if it's outside the U.S., there might be reasons that you have to file in a foreign country first. And also, if you do want to file outside the U.S., sometimes you can get a foreign filing license. You get one of those as a matter of course, typically, with some limited exceptions if you file a U.S. application first. But do make sure when you're talking with your patent attorney and you decide who inventors are, that you talk about citizenship and where inventive activities took place, because we can take care of some things that might be issues later on the front end. As far as where you want to file globally, filing all over the world is expensive and takes a lot of effort. So you want to really think about where you expect your sales to occur, which markets you want to protect. You want to think about where manufacturing might occur. Where might you manufacture? Where might competitors manufacture? Because you might want to have claims that go after the source, if you will. You also want to consider just how robust the patent enforcement scheme is in a country you're considering. You know, the U.S. has a very strong patent enforcement scheme that makes patents valuable. Other countries might have a little bit of a weaker scheme that doesn't import so much value to patents. These are all things to discuss with your business folks or your attorney to get some guidance. Just as a general overview, common jurisdictions for medical device patents include U.S., European Patent Office, China, Australia, Canada. Once you do get a patent granted through the European office, typically we see validations in the United Kingdom, France, and Germany. But again, that's all subject to change or to your individual circumstances. So with that, I thank you all for your attention, and I will turn it over to Doug.
Okay, thank you, Ryan. Before I get started, just Michelle, if you could give me a thumbs up if the sound sounds clear. I've been having some technical difficulties, so thank you. And Ryan, I noticed a follow-up question on that compound earlier question. Do you want to take that now or wait till the end?
I was asking about, okay, so this goes to that first question. I was asking about new medical use for an existing unpatentable compound, such as a medical use for an essential amino acid. Yeah, no, if that's true. So yeah, to answer that, yeah, new medical use for now.
Could you just share the question with the audience?
Yeah, the question was relating to that first question I answered and follow-ups, and the question says, was actually asking about a new medical use for an existing unpatentable compound, such as a specific medical use for an essential amino acid. A patent seems a tool unsuitable to prevent generic supplement makers from tacking on your medical use claims on their marketing materials. Yeah, to answer that though, you can get, if there's a known compound or an unpatentable compound, if there's a new use for it that is eligible to go after patents on, you see that from time to time. So that is an avenue. If you have a new use for an existing compound, you can certainly pursue claims on that. One more question came in. What type of strategy would you choose for an international application designated in the US and Europe? Do you think a patent attorney should draft claims in an EP or US fashion? Yeah, that's a great question. Yeah, we can get Doug's input on that as well. I try as best as I can to thread the needle. I do draft for the U.S., but I try to avoid certain things that I know to be problematic in Europe, so as to make the European patent attorney's job a little bit easier. And then in the specification itself, I try to put in support for European style claims, so that when we do go into Europe, we can have literal support, which is very, very important in Europe, for any of those European style claims to make their way into the disclosure. Doug, do you have thoughts on that?
No, I completely agree with you, Ryan, that at the end of the day, it comes down to what's in the specification and what's supported. So as long as you've got good, strong support in the spec, as you enter prosecution in different jurisdictions, usually you can amend the claims to satisfy local requirements. But obviously, because we are U.S. patent attorneys, we want to try to coordinate with local counsel. All right, well, good. So let's switch gears a little bit here. Good morning, everybody. Doug Portnow, patent attorney at Schwegman, based out of our Silicon Valley office. And I'm going to cover the back half of our top 10 topics today, starting with medical method claims. So I think there's a common misunderstanding or misperception of the value of medical method claims. I can't tell you how many times I hear my inventors say, well, it's not worth, getting a method claim out of this. Or I've even had CEOs tell other people, potentially investors, that, oh, well, we're not pursuing medical method claims. They're not valuable. And it just kind of, I think, is not an accurate statement. And in a way, it's actually, undervaluing the potential for these claims. And why are people saying that? Well, they say that they're not worth pursuing, that these claims cannot be enforced, or they're difficult to enforce, or even if you did, why would you want to sue your customer, the doctor, who's the one who's actually infringing those claims? And there are some valid comments there, but if we look at this from a legal analysis point of view and just sort of from a practical point of view, you'll see that I think medical method claims are in fact worth pursuing. So what is a medical method claim? Medical method claim would be a claim in a patent that is directed to the actions that are taken by the doctor or the operator that's performing the actual procedure. And why are they valuable? Well, even though you can't patent these claims in most jurisdictions outside the US and Australia, they still are valuable. If you think about claim scope, a method where you're talking about actions and not necessarily tying your claim to specific structure. In other words, you're just talking about what you're doing and you're not talking about the instruments that you're using to perform that procedure, then potentially you can get actually broader scope in a medical method claim than a device claim. And yes, while it's true that in the US you can't sue a doctor for literally infringing a medical method claim, that's in the US patent law. But where you can use a medical method claim is to potentially sue a competitor for an indirect infringement of that claim using the theories of either inducement of infringement or contributory infringement. So what does that mean from a practical point of view? If a competitor is teaching your medical method in their instructions for use, if their sales reps are out in the field telling doctors, do this procedure the following way, and that actually is what's claimed in your medical method claim, then you may have they may be inducing or contributing to infringement, and that's how you can actually sue that competitor. And so at the end of the day, bottom line, I think, is that these medical method claims are another tool or another weapon that you can potentially use to protect your invention. So, don't just think device claims are the only way to go. Medical method claims are also valuable, certainly in the US and Australia. patent term is always a very important thing, especially when it takes a long time to develop these products and get regulatory approval. So, you know, it may take you 5-10 years to develop a product and get some kind of regulatory clearance to commercialize the product, and then you've basically eaten half your patent term. And as Ryan mentioned, the standard patent term is 20 years from your non-provisional priority date in the US. If it's international off of PCT, that 20 year starts from the PCT date. So how can you maximize that 20 years? Can I get more than 20 years? And the answer is yes, you can. In the US, if the PTO is required to perform certain actions within certain time periods. For example, you're supposed to get an office action within, you know, a certain amount of time. I can't remember off the top of my head, but I think it's 14 months. But if the PTO does not issue that first office action within that time limit, then the PTO is tardy and you'll get some of that delay back in terms of patent term adjustment. That's PTA, patent term adjustment. That's automatically given by the patent office when your patent grants, and you'll see that on the cover sheet. Usually it'll say, you know, this patent is extended by X number of days, and it could be, you know, a week, a month, could be 1,000 days in some cases. I've seen it add up to be quite a few number of days. So those are automatically given by the patent office. You don't really have to worry about it too much. But you should definitely check those calculations using the formulas that the PTO has to make sure that they're accurate. The other type of patent term, extending patent term, is a PTE, patent term extension. And that is given under the Hatch-Waxman Act. And it's only given for PMA products. And it's given for delays caused by FDA review of your product. And the way that works is if you meet certain requirements, you'll automatically get that patent term extension, and it can be up to a total of 5 years on a single patent that covers the product that was approved under the PMA. So that's, again, a very important thing, especially, you know, if you're trying to extend the life of the product and extend the protection that you have. Some other mechanisms or ways of extending patent life are not specifically related to a patent that's already been granted, but as you make improvements on your product and you come up with new generations of products, obviously those improvements, you should consider filing new patent applications on those improvements so that they're protected. And then for our patent practitioners out there, you know, don't just automatically file their terminal disclaimers. Terminal disclaimer will automatically make 2 patents coterminous, meaning they expire at the same time. And that's basically to overcome a type of obviousness rejection that the patent examiner can issue. So a lot of times it's just easier to sign the terminal disclaimer or file it, and then you overcome the rejection. But sometimes it's worth actually arguing those double patenting rejections. So think about that. Of course, the risk is that you are characterizing your invention on the record, and then that could be problematic later on. Ownership and assignment are issues that come up quite frequently, so I want to just spend a little bit of time on that. I think everyone has a basic idea of ownership and assignment. But why is it important? Well, obviously, if there's IP that covers your invention and you don't own it, if somebody else owns it, then you're potentially liable for infringing that IP that somebody else owns. So it's important that you either own that IP or you have access to it via a license. And if you're going through any kind of fundraising activity, if you're going through an exit strategy like a merger acquisition or an IPO, the investors or the strategic companies will definitely want to make sure that you have ownership or access to that IP, because they're all about minimizing risk. They don't want to give you money and then have you get sued for infringement. So what do you need to do? Well, obviously you want your inventors to assign the IP rights to the company. You want to do that promptly. Inventors change jobs frequently. It can be hard to track people down. Sometimes when people leave jobs, they become disgruntled or not cooperative or uncooperative, and they don't want to sign forms. So obviously you want to try to get people to sign these documents while everyone is still on good terms and they're readily available. And the other thing is, don't forget that you want to record these assignments with the Patent Office promptly, because if there's a bad actor and there's a second assignment that's actually recorded before the first assignment, in certain situations that second assignment could actually beat the first assignment. And then so the second assignee actually wins and would own that IP. So there's a timing issue that you have to be aware of. And then obviously in any assignments, you want to make sure that in those documents, there's some clauses about ownership of other patent family members, not just the US, but foreign counterparts, continuations, divisionals, et cetera, et cetera. So we're talking about ownership of the entire patent family, not just an individual family member. And just like anything else, you want to audit these things from time to time, make sure they're correct. No typos, no misspellings. We see, errors all the time about ABC, LLC, ABC Inc., ABC Corporation. They have the wrong entity name, or is there a comma in between Inc. and the company name, that sort of thing. Those type of things happen all the time, and you want the chain of title to be nice and crisp and clean. And of course, your backup for all of this, if you can't get assignments, is to hopefully have an employment or consulting agreement with all your employees and consultants that has an IP assignment clause in there. I do see a quick question here, and I'll just read it out loud. It says, what can you do about an inventor who is uncooperative, will not sign assignment? So there's a couple of ways of dealing with that. If they're not going to sign anything, then that's going to be a real challenge. And that's why I say you should try to get these things signed promptly before people leave and become uncooperative. And then your backup is, of course, that consulting or employment agreement that can be used to record an assignment. And if you don't have those things, then yeah, it could be a huge problem and hold things up. All right. Talk very briefly about freedom to operate. What is freedom to operate? Well, Ryan talked earlier about patentability, meaning what's the prior art and how is that material or relevant to getting your patents claimed. They have to be novel or non-obvious and enabled. Freedom to operate is the other major component of patent studies or analyses that we perform. And that's basically seeing what other third-party patents are out there. In other words, patents owned by other grouped entities, people, companies that might have claims that would block you or prevent you from practicing your invention. And sometimes you'll hear this FTO term referred to as a product clearance study. So why do you want to do it? Again, obviously, if there's a patent out there that's blocking you, then you're dead in the water. You can't make, use, or sell your device without fear of potentially being sued for infringing somebody else's technology, somebody else's invention. I see there's a question about the employment contracts. I will jump back to that in just a second. Let me just talk a little bit about FTO and then I'll go backwards. So what do you do when you're running a freedom to operate study? Typically, you're going to look at your invention and you're going to sort of divide it up into the top key features or devices, features or mechanisms that it has, and then you can conduct studies, searches on those features and try to find the relevant patents that would have claims covering those or that are close to those. Then you can analyze those claims and hopefully come up with clearing arguments which distinguish what you're doing in your commercial product or process from those claims. So, simple example, if you have a balloon catheter, well, maybe there's some aspect of the balloon, how it's attached to the catheter. Maybe there's some unique steering wire mechanism in the catheter shaft. Maybe there's some actuator mechanism in the handle, something like that. So those are, just some very simple ways of dividing up your device into categories to help guide the searches that you do. But the bottom line again is you want to be able to distinguish what you're doing in your commercial product or process from what's claimed in those third-party patents. And remember, FTO analyses can really only be done when the product design is frozen. Otherwise, you're going to be searching and trying to hit a moving target. But it can be an iterative process. As you design things, you know certain features are going to be locked in, you're going to be using, so you can perform searches and analysis on those features. And then you can, as the design evolves, you can always update those things. So keep that in mind. So sorry to just go back a little bit. We had a follow-up question about employment contracts. And the question was, should employment contracts say employee hereby assigns or automatically assigns rather than will assign? So that's a good question. And that goes to the present assignment versus future assignment clause. So you don't, if you had a clause in the assignment that says the inventor will assign, that's future event. I don't know when the future is. It could be now or a year or 10 years. So that doesn't really help you with the assignment. So that is correct. You need a present assignment clause, which is the inventor hereby assigns this invention, meaning now. Hope that answers that question. Let's move on to category number 10, which is sort of a little bit of a catch-all. And let's go through it real quick. IP due diligence, again, we deal with a lot of startup companies, and what do startup companies always do? They're always trying to raise money, right? So whenever they're trying to raise money, whenever there's a merger acquisition, IPO, if they're trying to sell a patent or license it, there's gonna be some kind of IP due diligence because the investor or the acquirer wants to evaluate the risk associated with that IP. So IP due diligence is an assessment of risk of the IP in your portfolio, as well as how third-party patents or other IP may affect what you're doing. And the goal here, if you're on the company side, is you want to create a credible story that addresses your IP position, that you've got good, strong patents with broad coverage. You want to have a story that there's no freedom to operate issues. You want to be able to explain why your claims have commercial value. And we'll just kind of go through a couple quick tips here at a very high level. Again, this is kind of the devil's in the detail with diligence, but starting with, make sure you have a master schedule of your IP. I can't tell you how many times we've performed diligence on target companies and they can't even come up with a list of all their patents. So it doesn't make a very favorable impression at the beginning. So try to have that master list. And don't be shy about asking whoever's performing due diligence on you, ask them for their list of questions because that will just really help you prepare for that due diligence. You can prepare those responses and they can be well thought of rather than just sort of off the cuff kind of remarks. But again, demonstrating ownership or licensing of the relevant IP is very critical. Any claims that you have or that you're pursuing, you want to be able to understand and explain why those claims are commercially valuable or relevant to what you're doing. You should know the most relevant prior art and be ready to discuss it, why it does not, or why it does or does not affect patentability, your ability to get those claims, and how do those claims affect your freedom to operate or product clearance position. Obviously, you don't want to have FTO issues. If you do, that could be devastating as far as any kind of fundraising or exit type of strategies. And when I do diligence, I mean, we know when people are telling us the truth. We know when people are kind of not telling us the truth or making things up, because this is a very factually based type of analysis. So I always tell clients that, it's better if this deal goes through for both parties. It's a win-win. The company gets the money and the investor gets the investment. So it's better to cooperate. It's better to be open and candid about potential issues. That way, both parties can try to work out solutions. If there are disgruntled ex-employees who aren't signing things or filed their own patents, sort of went rogue, can talk about that and try to work it out rather than trying to bury it, because people, we will find that. If you received any nasty grams, cease and desist letters, if there's litigation, again, it's better to be candid about that up front and talk about it. Portfolio management, won't spend too much time on that, but obviously having intellectual property, whether it's patents, trademarks, or any of the other categories that Ryan talked about, is a very resource intense activity. It's kind of like having pets, right? If you have a pet, you need to feed your pet, you need to bathe your pet, you need to take your pet to the vet, and they need a lot of tender loving care. Well, patents, trademarks, all of those are the same thing. They require time and attention and money. So you need to manage your portfolio and make sure that budgets are satisfied, make sure that there's no issues with the portfolio, assignments are up to date, the claims are where they need to be. So, a few things to think about are prioritizing inventions, managing the budgets, watching all of those type of the numbers. Foreign protection can be very, very costly. So again, watch where you're filing. Don't just file in every single country, because when the bill comes, you're going to have a heart attack, because it can be very, very costly. If you're going through the European Patent Office for European protection, you'll need to validate those patents in specific countries in Europe in order to make them enforceable in those jurisdictions. So again, don't just don't just validate in every single European jurisdiction, because there's going to be a lot of costs associated with that. So you need to pick strategically where your markets are that you want to protect. And on the US side, there are maintenance fees that are at 3.5, 7.5, and 11 years. So that's additional government fees that you have to pay. Those are increasing fees. And same thing with foreign cases. There are annual annuities. That's like a patent tax that you have to pay. So again, the more countries, the more filings, these costs add up. So, you want to just make sure that you're filing in the right places and on the right subject matter. Patent valuation, I'll just touch on this very briefly. Like Ryan said, you may want to monetize your patent. So patents are like a house. You can live in the house, you can sell the house, or you can rent the house out, meaning you can exploit your invention, you can license your invention, or you can sell your invention. So if any of those transactions are going on, you need to do some kind of valuation. And the three typical models that we see are the comps method. Again, that's very much like selling a house. You find a house that's in the same neighborhood as yours and similar floor plan, and you can find out easily how much that house went for, and that can give you a good basis or benchmark for what your house is worth. On the patent side, it can be more challenging to find that information, but sometimes it's out there. For example, in the mitral valve space, which is a relatively hot area right now, there's been a lot of merger acquisition activity, and a lot of those transactions have been published. So, it kind of gives you a rough idea what some of those companies are worth. Of course, the assumption is that the market is rational, and I'll leave it up to you to decide whether the market is rational or not. The second method for valuation is the equivalent R&D cost method. So meaning, in order for me to develop that technology, it's going to cost me X amount of dollars. So that would be what that patent portfolio is worth. And it's kind of an educated guess, because who knows how much these things really are going to cost. I think we can take a reasonably good guess, but you may have problems along the way. And then the third method is the discounted cash flow method. So there you have an invention, and you can figure out what your sales forecast is for the life of the patent. And then when you use the discounted cash flow method to figure out what the net present value of that revenue stream is, that will give you a value in today's dollars. So again, it's sort of an educated, semi-educated guess. And again, there's no right or wrong to any of these. I think comps, to me, is probably the most accurate, because that's what the market will bear. The other ones are a little more theoretical, if you will. I just want to touch on data analytics very briefly. in these days of software and big data and all kinds of things, firms such as ours, we have all kinds of really neat tools that allow you to very quickly go out and scrape data that's publicly available. So here we had somebody ask us, hey, what's going on in the drug-eluting balloon space? So we did a real quick search, and we found, guess what? There's a lot of activity in the 2016-17 timeframe. So, that was clearly when there was a lot of activity. We did some further searching. We were able to identify who kind of the key players in that space was. And from there, we're able to, pull out specific patent applications. And we can really create a pretty nice landscape of what's going on in that space. So the analytics part is a very useful tool, and we encourage all of our clients to use these tools when they're available. So just to kind of wrap things up, patents are a very important part of an IP portfolio, but don't forget there are other forms of IP out there, trademarks, trade secrets, and copyrights that can also be very valuable. And you want to create a comprehensive portfolio that has hopefully some or all of those different types of IP. And then just be ready to have a good story of what your IP position is, because you may be going through due diligence or other issues when you're talking to companies. And that includes positions on, how good your claims are, what's your FTO position, and how's the ownership. And then, of course, monitor and manage the portfolio so you don't break the bank. With that, I think we have a few minutes left and open it up to questions. So feel free to send your questions on the Q&A. I had a question about whether our analytics are specific to our firm. We have our own tools that we've developed in-house, which is what I just showed you. There are obviously other things that we can look at. I just gave you a quick view of those analytics, but some of the other patent service providers also have their own tools. I believe some of the big ones, the Lexis, those kind of firms have their own analytics platforms as well. There's a question about searching, let's see, not FTO, but patentability prior to drafting the patent application. Costly, sure, when is the cost justified? I'll give you my 2 cents, and then Ryan, feel free to jump in if you want to add anything. But the more you're familiar with the prior art, the better, the stronger your patent application is going to be. There certainly is no duty to perform that as far as the PTO concerned. So if the budget permits it, if your timing permits it, I would definitely recommend doing some patentability searching before filing a patent application. And that'll give you an idea of what kind of claims you can reasonably expect. And the cost can be anywhere from $2,000, $3,000, $4,000 to higher, depending on what you're searching and how much you're searching. Ryan, do you have any thoughts on patentability searching?
I think you're completely correct there. One thing, if I have clients who are a little hesitant to put up the cost to do patentability search on the front end, I just encourage you to, if you're at a university and you have faculty inventors, or if you're at a company and you're talking to your technical team, just they will have for the most part, a good idea of what the state of the art is. And if you press them and work with them, if you can't afford a patentability search, at least try to work with them to get a good feel for what the art is, so that you can go in a little bit informed and go in with your patent attorney with your understanding of what the art is. And that's a way, if you're a little bit hesitant to do a search, that you can at least kind of mitigate that and go into the patent process a little bit more informed.
Okay, I see another question here. Should device and method claims be combined? I assume the question is asking whether those claims should be combined in one application. The answer is yes, you can certainly do that. But it's highly likely that the patent examiner will consider those separate inventions because they require separate searches. And therefore, due to the burden of doing multiple searches, the examiner would divisionalize those, and you'd have to pick one for the first application, cancel the other set of claims out, and then refile the canceled claims in a divisional application later on. Let's see, we had another question about how to defend AI or machine learning medical patent. Not sure I understand the question, but certainly AI and machine learning is eligible subject matter, and certainly in a medical device patent, we're seeing a lot more algorithms and things like that. So if the application and the claims are drafted correctly, you can certainly get those claims. Ryan, anything you want to add to AI or machine learning?
No, it's just, yeah, to the extent that it might provoke a subject matter eligibility rejection, there are ways to handle it, and we certainly see that a lot, and it's kind of a case-by-case thing, but Doug's right that you want to anticipate that might be an issue when you're drafting that, and keep in mind to put in the support you need in the specification to arm yourself as best you can against eligibility rejections.
Okay, we're just out of time here, so I think we're going to have to end it today. If I apologize if we didn't get to your question, feel free to email us, call us. We'd be happy to talk to you offline. Thank you very much for joining our webinar today. So I'll turn it over to Ryan and Michelle.
Thanks, Doug, and thanks, Doug and Ryan, so much for the presentation. And thank you, everyone, for joining us today. And our next webinar will take place on Thursday, July 9th, and it will be in the Patent Analytics webinar series. So we would love to see you back for that. And thank you again. Be well.
Thank you.
Bye.